Hello, everybody. It's Dave Neal with an update in the Justin Baldoni versus Blake Lively court case that's happening out there. Shots fired in all directions, and we have a new motion that has been filed, or I should say a response, by Stephanie Jones of Joneswork. That is the PR person that was hired by Wayfarer and Justin Baldoni. Of course, Justin Baldoni didn't want to work with Stephanie Jones, wanted to work with Jennifer Abel, the employee of Stephanie Jones, and when Jennifer Abel tried to leave her contract, that's when Stephanie Jones said, "I'm going to take your cell phone." And she went through it, found all the DMs, text messages of trash talking and whatnot, and sent those over to Blake Lively. But they didn't have a subpoena, so she would have been violating all of the confidentiality agreements. So Blake Lively used a shadow business, Van Zandt, to file a sham lawsuit to get a subpoena to get those records, then withdrew the lawsuit like the next day. Pretty sketchy stuff, right? Well, sketchy is our middle name. So this is a special bonus episode where we're going to dive directly into this case. So again, and if you aren't familiar with my channel yet, I do a morning episode and an afternoon episode, and then when there's something I can specifically talk about for a longer time, like reading this court document, then I'll do an extra episode. It's a lot of content. And some people say, "Dave, can't you make these videos all separate?" Well, I could, but that's like going to a steakhouse and saying, "I don't want the potatoes, I don't want your arugula salad, just give me a bear steak." I'm not here to serve you a bear steak. I'm here to serve you some of the other things, and you can decide what you want on your own plate, but it's all coming bundled up here. No a la carte from me, although this video is a la carte. So, third-party defendant Joneswork LLC reply in further support of its motion to dismiss Jennifer Abel's third-party complaint seeking indemnification. All right, and of course, I have no law degree, so as I read this, it's from such an elementary level. But hey, that's most of us, right? And by the way, this is just fascinating to see what is basically on the Baldoni versus Blake Lively side. There's a harassment accusation by Blake Lively. There's a lot of accusations. There was that Justin Baldoni was committing an infliction of emotional distress. She has pulled out of that accusation, but there are still plenty of heavy ones, enough to kill a career. But this one's really a workplace one. This is a workplace one, this parallel lawsuit that is Joneswork and Jennifer Abel. This is not good for Joneswork. After I make this video, I'm going to share with you the other side of the PR world, which is Leslie Sloan, Blake Lively's PR person, and how somebody is going on the record to say how Leslie Sloan fakes crimes to silence the press. What? That's going to be crazy, so stick around for that. That'll be on the afternoon rush. But let's dive right into this one. Let's skip the table of contents. Just read a little bit for you here. Jennifer Abel seeks to have it both ways. She alleges in counterclaims before this court that she was pursuing her own agenda despite being hindered in her efforts by her employer. Yet here, she reverses course, claiming that her efforts fall under the purview of indemnification. She cannot do both, and her plea for indemnification must fail. In opposition, Abel tellingly runs away from her own words and admissions, tacitly acknowledging that the text messages that she has admitted to sending and receiving into her parallel filings doom her claims. Abel bizarrely insists in opposition that this court not consider the very actions for which she now seeks indemnification. She is mistaken, and when properly considered, the reality is beyond dispute. Abel's clandestine actions, she's a spy, defied her employer and were instead in pursuit of personal interests. Indemnification and contribution claims cannot be sustained in the face of these pleaded admissions and should be dismissed. You know what's so funny is that they accuse Jennifer Abel of clandestine actions when the only person spying, as far as we know, is Stephanie Jones of Joneswork. And by the way, this is terrible for Stephanie Jones to be in this lawsuit. The only thing celebrity clients want when they hire a PR person is to clean up their image or keep their image clean. By being associated with Jennifer Abel or Stephanie Jones or any of these folks, really, Leslie Sloan, by being associated with any of them, it's just adding spotlight. And in this case, a lot of real celebrities, like the big celebrities, They don't want the spotlight, right? They're not calling paparazzi. That's for C-list celebrities to do. They just want, promote the movie when it comes out and stay out of my kid's preschool when it doesn't. So here's their argument. Jennifer Abel cannot confine the court's review to avoid dismissal. Apparently, recognizing that her own pleadings, words, and actions doom her claim for indemnification, Abel seeks to improperly narrow the scope of what this court may consider in resolving Joneswork's motion. She cannot do so. First, Abel argues that the court cannot consider Lively's amended complaint or her own answer to it, but Abel's own case law bellies this argument. And then they go into the case law, which again is that's above our pay grade. Indeed, that's for ChatGPT. Indeed, these cases make clear that facts stated on the face of the complaint documents incorporated in the complaints by reference, matters in which judicial notice may be taken, and documents integral to a claim for indemnification must be considered. All right, so they get into the legal argument there. And nothing is more integral to Abel's claim that Jonesworks should be financially responsible for Abel's misconduct, as alleged by Lively, than Lively's amended complaint setting forth the alleged misconduct for which Abel now seeks indemnification, as well as Abel's answer responding to these claims of misconduct. And look, I might have this wrong, but I think if you're Jennifer Abel, there might be multiple claims to make. One, I'm not liable for anything because I was working on behalf of Stephanie Jones, and Stephanie Jones says, yeah, but you were trying to leave. Yeah, but I didn't. It's like, what do you want? I was trying to leave and be on my own, but I was still working under you. So it's kind of like a game of hot potato here, it seems. At the core of what this court must decide, whether Abel plausibly alleges that the actions described in Lively's amended complaint in her answer to it were within the scope of Abel's employment. And Abel herself expressly relies on the allegations in Lively's amended complaint in defending the vagueness of her contribution claim, expressly incorporating as support for her claims Lively's claims against Abel and the alleged injuries about which Lively complains. So my thought is this. There is no smoking gun with the theory that Baldoni's side had a smear campaign. There's Jed's going to take care of this, kind of like mafia level talk. But you would think at this point, if there were a smoking gun, they would have an invoice from Jed Wallace. They would have, more verbiage about what was being said or done to create this smear campaign. The reason it doesn't exist is because most likely the most obvious thought and consideration is that fans just don't like Blake Lively. They just didn't like her. And there was no coordinated effort to take her down. It was, just done by the fans. Abel seeks to disavow her numerous other pleadings, including in the related action. Abel cannot hide those allegations and admissions to avoid their legal consequences. The inconsistencies and implications of her own pleadings and admissions can and should be considered in evaluating her claim. Lastly, this court should reject Abel's plea that it disregard her own incriminating communications and admissions based on the specious argument that Joneswork's inclusion of Abel's own words in its motion was deceptive. For instance, Abel argues that Joneswork's claims that Abel developed and executed a smear campaign to bury and destroy Lively constitutes deceptive conduct, even though Abel admits in her pleadings to exchanging those messages with Melissa Nathan, in which the two planned just that. Answer to Lively, Abel has no response to these statements and cannot evade the effects of her own admissions by leveling groundless complaints about her own words being used against her. Now, in defense of Jennifer Abel, and I know this is just a lot of nonsense here, but in defense of Jennifer Abel, Stephanie Jones and Blake Lively, that whole side, they did misconstrue what was said. They did cherry pick messages. And even if you said the words bury, destroy, smear campaign, even if you said all those words, the context, the before, the middle, and the after means a lot. And as I read all of that, I didn't see any smoking gun that they had a smear campaign. They might have been developing a response in case there were a smear campaign. But I think Stephanie Jones' side here is trying to play the judge and everyone else for a fool. In response to Joneswork's argument that the New York choice of law... Okay, I don't want to read the choice of law BS, because then they talk about why they should reject the claims. New York law applies to all aspects of Abel's employment. Abel nonsensically next argues that even if not void, New York choice of law provision still does not preclude her California statutory... So they get into the, what, jurisdiction and laws of state, employment law in New York versus California. That's what's so complicated about the film industry is you got people coming from California, Texas, New York. The thing was shot in New York. Blake lives in New York. Wayfair is based in LA. All of these kind of, so again, more hot potato, like what jurisdiction and laws will be cited to, and you really do understand why you need to be licensed as a lawyer in different states because the laws do become quite tricky. The law Abel cites is inapplicable. Each case to which she cites in support of her proposition that a choice of law provision only applies to issues concerning the agreement involve choice of law provisions expressly limited to that agreement without the broader language, including in Abel's contract. That encompasses non-contractual causes of action. So, anyhow, Abel cannot rely on this court's decision in Stevens & Co. to support her argument that the 2021 Employment Agreement's choice of law clause does not reach Abel's California statutory cause of action for indemnification. Let's just fast forward to this nonsense. Abel does not plausibly allege that her harmful conduct was within the scope of her employment. Abel's entirely unsupported arguments that she was acting within the scope of her employment are without merit. Abel offers no case law supporting her wishful argument that her express defiance of Joneswork's instructions in quest for personal enrichment or within the scope of her employment. You know what's interesting to me is the judge hasn't ruled on one of these motions to dismiss, right? On one of them. And yet here we are, inching our way to March of 2026. It doesn't sound like it's that close, but it's a lot closer now than it was months ago. I said when I spoke to Ask Two Lawyers that I thought this case would be settled on July 3rd of 2025, mainly because I believed they would try to take the wind out of the sails of the PR. They always say, if you don't want something reported on, do it on, make it on a Friday, afternoon because people will be gone for the weekend. But the day before, or maybe even the day of 4th of July, right, would be an excellent time to settle. Although with this case being as big as it is, it might take a little bit of the wind out of the sails, but not a lot. But there's so many things in action here. There's so many, Stephanie Jones and her former employer, Blake versus Justin. Then you've got Justin versus the New York Times. That'll probably if anything gets dismissed, that'll probably get dismissed. So there's so many things going on that my thought that it would settle on July 3rd of 2025 is gone. I'm thinking now either Christmas time, but then you go, well, why settle around Christmas time when the discovery is due August or September, because why go through all the pain of doing depositions and then settling? So it looks like this thing's going to trial. Now, I told you guys, if you get me to 100,000 subscribers, I said, if you get me to 100,000 subscribers, I will personally go to New York City for the entirety of this trial. Well, I am not quashing that decision. And I wanted to give you guys a heads up because not only did you get me to 100,000 subscribers, you blew that out of the water. Now, I'll be in New York on June 19th to the 25th. I have a bunch of stand-up shows. Actually, I have a stand-up show tomorrow night, Thursday night in Franklin, Tennessee. If you want to come to that, go to my Instagram, dneils, for updates. But either way, I've got a show at Stand Up New York. I've got a show maybe at The Stand, maybe at New York Comedy Club. I've got a show at West Side Comedy Club. So I'll be Upper West Side. I'll be East Village. I've got shows Midtown. I'm going to be all over New York. So if you want to come to a show. The point of what I was saying is that I'm part of a new housing swap community. So I'll be staying in New York for the week in Chelsea. But when this thing goes to trial, I'm going to just rent an apartment. So I'm going to put some money down and make sure my wife, my baby, and myself are in a nice apartment, secured, baby secures, beautiful, we're going to be that cute little family getting, baguettes. Although if it's in March of 2026, we'll have to get our hunter boots because if you know New York, those puddles are pretty deep. Just when you think it's only an inch puddle, next thing you know, you're down to your waist in waders. You've fallen into some sort of slick trash water as it piles up. So either way, I will be there. You guys made this happen because you hit the subscribe button. And we'll be back this afternoon to discuss what is probably a juicier story, that being somebody going on record to explain the extortionary techniques that Leslie Sloan, Blake Lively's publicist, uses to threaten people. Pretty wild stuff. That coming next.